basically, the government sent out hundreds of pages of unencrypted information to your members by your own testimony, Ms. Mason, included client protest activities via email with little or no privacy safeguards from their perspective or direction to you. Is that correct?
That is correct. They were delivered in that process.
And they provided no safeguards or direction for you on how to safeguard that data, correct?
They did not provide such instructions.
So did the Banking Association safeguard this personal data?
Motz wonders why the banks and credit unions didn't seek legal opinions when freezing bank accounts. Witness explains they didn't need to because of the Emergency Act, and the government told them. Also, there was no safeguard in place of transferred information, which caused a privacy breach. Here's the clip.
Thank you, Chair, and thank you for the witnesses for being here. As we've heard, and we know that the Emergencies Act regulations included the arbitrary freezing of individual and business bank accounts. Now, before acting to implement the government's Emergencies Act, did any of you seek any outside legal opinion on that what the government was doing was lawful? Yes or no? Mr. Hatch? No. Ms. Mason?
No.
So if not, why didn't you seek outside legal opinion?
I'm happy to take that.
Yeah, go ahead,
one.
Angelina.
Sure.
I can go after you if that's okay.
Yeah, I have limited time, and I'll cut you off if you're too long. So.
Okay. The Emergencies Act the scope of the act was designed for a state of emergency. One was declared by the government, and once that occurred, then the obligations became in force at law. We had obligations to fulfill them. We were well aware that the Emergencies Act, as it was created, would have a post-act review that would assure whether or not any of those powers had been exercised.
So, in other words, you trusted that what the government was doing was legal. So, normally, bank accounts are frozen as a result of a court order. Generally, there was no orders this time, just the Emergency Act regs. Again, this was all unprecedented, incredibly unprecedented. Would you not feel it prudent to seek outside legal counsel before enacting these unprecedented measures, especially given that they, at the very least, have the appearance of being politically motivated?
I mean, I would say in the heat of the crisis, it was not our role to determine the legality of the government's invocation of the act, which, in our view at the time, was a sound legal application of an existing statute. It wasn't our role to question whether that was right or wrong. Our role as a trade association serving our members was to act as a conduit between the government, between finance, and our 200 plus credit unions out there in the country who at the time were scrambling for information.
Right, scrambling, and just like your customers were scrambling. Are you aware of any specific written directives being provided to any financial institution from any government minister with respect to the implementation of the Emergencies Act? Ms. Mason?
No.
Mr. Hatch?
Likewise, no.
Who ultimately made the decision to freeze bank accounts?
That's a more complicated question. As part of my opening remarks, I mentioned that one of the many difficulties that we experienced in this process is that the government did grant financial institutions significant leeway and discretion in terms of which accounts to freeze. That's one side of the coin. The other side of the coin, of course, is that there was a list provided by the RCMP.
I'll disagree on this point. I don't think.
I'm sorry, my apologies. If we could allow I'm going to pause for a second, just in a procedural, bit of a procedural intervention. We're going to allow the member to direct the questions, and the person who is asked the questions will answer them, and we'll continue on that way. Mr. Motz, I paused the time. The floor is back to you, sir.
Thank you, Chair, and thank you, witnesses, for your indulgence. What was the basis for the decision that your institutions made to freeze bank accounts? Quickly.
The basis of the decision was that someone was on the list as a designated person. And again, my point would be is if there was no discretion there, we had a legal obligation to freeze if they were a designated person.
Okay, so again, you trusted government. Are you aware of any financial institution questioning the RCMP's rationale for including certain individuals on their list of accounts that were allegedly involved in the convoy?
No.
I am not aware.
did the RCMP provide any probable cause, any evidence, anything equivalent of a search warrant of any alleged criminal activity by those whose accounts you were asked to freeze when the RCMP provided you those lists?
That would be a question better directed at the RCMP, Mr. Chair.
No. You're the financial institution?
Through the chair?
Thank you. You're the financial institution? And usually when you receive a court order, there's evidence there to suggest that you have some obligation. So I take it by your answer, the RCMP did not provide any evidence of any criminal wrongdoing.
Not to my knowledge. They provided a list, which was, it bears,
so
it
that's
bears
fair.
repeating, a very targeted and short list. But beyond the list, there was also, in addition, the latitude granted to financial institutions to freeze further accounts if they so chose. Now,
Right,
in our example, they did not choose to.
institutions- Sorry, Mr. Hatch. Do financial institutions not require law enforcement to at least provide the reasoning when asking for individual accounts to be frozen?
Not under the invocation of the emergency orders, no.
Okay, but
These were
you haven't got legal
extraordinary
counsel to
measures.
give.
Sorry,
Well,
apologies.
according to the government, the
We,
reason we're here today,
we-
the reason we're here in this committee is to determine whether the government even had, met the threshold to invoke.
We
an
are
emergency act.
at the end of the intervention.
The released minutes of a February 21st secret cabinet meeting indicate that our Deputy Prime Minister and Minister of Finance Freeland stated, and I quote, the minutes reported on a conversation that she had with CEOs of the major banks. Banks were pleased that the government was working on a plan that would see individuals with their accounts frozen report to the police prior to the bank having their accounts frozen, end of quote. Now, did at any time the minister or a staff member of Finance Canada ask banks, your banks, how many accounts have been frozen, or pushing for banks to act faster, or question why more accounts have not been frozen?
We definitely got questions. We know the minister reached out individually to some of our banks, and we've got from the finance officials themselves questions about the number of accounts frozen because they wanted to understand that the order was being implemented and felt it important to say what the impact was. I think they were interested also on the basis for the numbers that we were producing, and we explained that the numbers that we had were in large part due to the fact that we needed to rely heavily on the lists provided by the RCMP.
Okay. Now, for both of you, were there any restrictions placed on how the private information of Canadians received from the RCMP could be used, or for how long it could be relied upon? Yes, no?
There were no instructions when the information was provided. We did ask the question at the beginning, given how sanctions laws work where that list is public, whether or not this was a confidential list or a private list. We was told it was a confidential list, and that's why we only shared it on a need-to-know basis, but there were no specific instructions. Having said that, privacy law does kick into effect, which requires that you only hold information as necessary for the purpose for which it was collected.
Right. Any difference from that, Mr. Hatch?
No difference from our experience. That's correct.
Thank you. So basically, the government sent out hundreds of pages of unencrypted information to your members by your own testimony, Ms. Mason, included client protest activities via email with little or no privacy safeguards from their perspective or direction to you. Is that correct?
That is correct. They were delivered in that process.
And they provided no safeguards or direction for you on how to safeguard that data, correct?
They did not provide such instructions.
So did the Banking Association safeguard this personal data?
Yes, we ensured that it was only shared on a need-to-know basis, and then we actually arranged so that our members could receive that information directly.
Okay, and yours about the same, Mr. Hatch?
Yes, we shared it only on a very secure,
Okay.
members-only online channel.
Thank you. So have your members destroyed that information yet? Yes or no?
I don't know the answer to that question, but I'm happy to get back to you.
And Ms. Mason, yes or no?
I would have to get back to you on it.
Can you both undertake to do that and report back to the committee from your members on whether that has been destroyed? Now, Is there anything in the emergency order that prevents your banking members, Ms. Mason, from continuing to use the intelligence received from the RCMP now in your own personal risk assessments as banks of your clients? And are these accounts still identified by the banks as having been on the government's hit list or the blacklist, outside of those with court orders we've already identified?
There's nothing in the order itself that prevents that. There would have been some indication on the account itself so that the bank could answer any questions as to why certain actions were taken on that account.
And again, this is not an indictment against the banking or the financial institutions, but the fact that the order itself is void of any direction that when the order is lifted, you can't use that data for any of your own purposes. And that's my point. So you've answered that there was no direction provided. One last comment. One could argue that consumer confidence is the foundation of a worldwide financial system. If people lose confidence that banks and other financial institutions are not capable of keeping their money safe, and that's when we get runs on banks, even though at this point in time you said it was minimal. Money supply could be threatened and institutions that we rely on every day break down. The government's use of the Emergencies Act to freeze bank accounts of individuals was unprecedented. Would you agree that those unprecedented measures have had a negative impact on the confidence Canadians have in the banking system? Mr. Hatch, yes or no?
At the time, yes, but
Ms. Mason?
I would say we weathered this storm, but that was in large part due to the fact that it was very short-lived.
Mr. Chair,
Thank
he
you.
was.
I
The witness
understand.
was attempting to finish his answer and he was cut off. by
I don't
Mr.
believe
Motz.
that that's a point of order, but I will say that the round is done, and I do appreciate the editorial.
Senator Patterson. Mr. Hatch, I just wanted to encourage you to maybe reconsider a response that you provided where you said that you didn't think that it was appropriate to given the minuscule impact that the EA had on your clients. But I think, as Senator Boniface asked, have you done a postmortem, or are you going to consider to do one? It's your customer base. They may have a different view, and I would encourage you to maybe, with your 200 and some, branches across the country, that you would reconsider that, because this is an unprecedented event, and I think your clients might appreciate it. Ms. Mason, I have a question
Point of
for you.
order, Mr. Chair. I wonder.
Can you stop my time, please? I have a question for Ms. Mason.
I apologize for interrupting my colleague. I'm not aware of the rules. So any member can cede their time to any other member, including a senator, to a member of the House?
I think it's his time to cede, so procedurally I don't see that out of order.
It's just never happened, Mr. Chair. We've always had senators ceding their times to other senators.
Fair enough.
And
As
members
opposed-
of the House ceding their time to other members of the House.
I don't think it's
Maybe we'll have to
outlined in
change
any standing orders that I've seen. If you have one for reference, feel free to do that, but in the time being, I'll grant the parliamentary privilege of Senator Patterson to cede his time to whomever he so sees fit. And in this moment, it happens to be Mr. Motz.
Thank you, Chair, and I certainly concur with your ruling. Ms. Mason, this question is related to you. As you are aware, and the Emergencies Act, the whole premise around it was to be charter compliant. That was the rule around it. If you read the Act over again, that there's a charter compliance requirement there. So in light of the government's regulations under the Emergencies Act, to have a third party, namely you, the banking institutions, financial institution, freeze accounts, do you not believe that the government was circumventing their charter obligations with respect to search and seizure?
I think that's for this committee and for the public commission to assess from a legal perspective.
Well, that's a nice skate. However, you're the banking institutions who represent the banking community who was asked to do this on behalf of your clients. So I find it odd that as general counsel, you wouldn't think that there's some obligations you also have to your clients under the charter.
No, the reason I say it that way is because both this hearing and the public commission are collecting information and creating findings on what actually took place. There have been competing versions of what was intended and how things were implemented. So all I'm saying is that when all the facts are before us, that is when we are in the best position to assess whether or not we felt the charter had in fact been respected.
Fair enough, and I appreciate those comments. And you're right. Hopefully, you'll never be, as the banking institutions, be in this position again where the government could invoke this on the Canadian citizens for this reason. Now, Ms. Mason, are you aware, did anyone from government or any law enforcement agency seek input from the banking associations prior to the invocation of the Emergencies Act or the request to freeze accounts? I know you indicated earlier that you got a heads up that it was coming. But previous to that, was there any indication from them? Did they seek your advice on how to do it from a banking perspective?
No, we never. We were never approached to ask about how to seize accounts from a banking perspective.
Okay, and Mr. Hatch, given the fact that you weren't even included in those conversations, I suspect you're in the same boat.
Correct. Yeah, we were not given any advance warning. Quite the contrary, as I've already described.
Right. And I agree with that assessment that it's unfortunate that you weren't considered to be, part of the financial institution concept and with the EA. Anyway, I am done given the time, Mr. Chair.